agenda speaks of discussion of environmental testing of 600 Ridge Road. That, in fact, is what is the ultimate subject of this, but I've handed out something to all of you. I'm glad that Chad is here because he's very familiar with this. I've been doing some looking into and research into what needs to be done at the site, and I'm going to speak in generalities because this would be for any site that we're talking about, but as a prelude, I just want to mention that, and Matt is aware of this because he assisted with an attempt to get a grant back in 2017, I believe it was, which we didn't get, but the prior administration was working on this probably since 2014. We've been trying to do something with this corner, and it's gone through numerous owners. There was a prior owner of the building who passed away. It went to his estate. It was then foreclosed upon numerous times by the county for failure to pay taxes. And so we've had a problem finding an actual owner, and plus there's been tax liens in the tens of thousands of dollars on this property. So we've been stopped from doing much of anything because we couldn't find out who the owner was. There have been multiple owners since the prior owner passed away. Those owners who purchased the tax liens, I would say the tax lien owners on the property. Furthermore, there's issues with the environmental, potential environmental concerns with the property because it was a furniture stripping store. There were a lot of chemicals used in the business that was conducted there. We have met numerous times in the recent last year or so since Supervisor Flaherty's been in office with the county. And we, I believe, have a path going forward. I'm going to explain some of the items that need to be looked at and done and where the county comes in on this. Basically, I've handed you just a couple of pieces of paper here, and you can make notes if you wish. Main question is cleaning up of what's called brownfields. I mean, a brownfield is basically any property that has been environmentally damaged and needs cleaning before it can be properly used. There are numerous agencies, both federal and state. The state agencies, the Department of Environmental Conservation, the federal agencies, Environmental Protection Agency. But the state regulations pretty much govern what we can do. And there are basically three types of actions that a municipality or a proposed developer or owner needs to do in looking at a property such as 600 Ridge. And those are called Phase 1, Phase 2, and Phase 3 site assessments. Now, Phase 1 assessment it's a study conducted on a property to evaluate the likelihood of environmental contamination. That's right from the law and regulations. Generally, the costs are between $1,000 and $2,000, and I believe we have done the Phase 1 on this property, correct? Or it's been done.
We were able to obtain, without paying specifically for a Phase 1, we obtained oil records from DEC on this property that has been accepted
It's effective.
by Phase 1, yeah.
Right.
It was free.
Correct. Yeah, well, it didn't cost us anything.
It didn't cost us.
Which is great, but it's effectively been done.
Yes.
All right. Having had that information, we presented that to the county, which has been foreclosing on it routinely for failure to pay taxes. And we are hoping to go to a Phase 2. Now, that's a follow-up to Phase 1. It's also known as a subsurface investigation or a site investigation. And this means actually entering the property, collecting samples of soil, soil gas, vapor intrusion, groundwater samples, and then sending the same to a laboratory for impact. Now, generally the costs are between $5,000 and $100,000, and a property like this is probably closer to the lower amount initially. Once that is done, it's determined whether or not Phase 3, which is removal of any contamination and remediation, is recommended. And Bill, feel free, I know you're an expert in this, so feel free to jump in at any time on this. Now, where we are right now is with the property, this particular property, is we have talked to the county, and we are in process of working with them under the environmental conservation law, particularly section 56-0508, because they, having the authority and the power to foreclose on a tax lien. I'm going to read this. This is dry, but I'm going to read it. May, upon 20 days' notice, seek an order of the court obtaining, quote, temporary incidents of ownership of such of a property for the sole purpose of entering the property and conducting an environmental restorative investigation. I don't know if the county's ever done this before. We did meet with various people in the county, the real property manager, real property office, the deputy county attorney, etc. They are interested in doing this. They did foreclose for, I think, the third time last week on the 15th. The property was attempted to be sold at the standard foreclosure auction. Nobody bought it, so the county effectively owns the property. They would have to, however, as the agency foreclosing, go to court and seek the quote-unquote temporary incidents of ownership so that they or somebody that they designate may enter the property. Right now, the town cannot enter this property. We don't have the authority or right to do it. It is still private property. So, hopefully that will be done within the next month or two. They will have to go to court. They will determine what the cost of a phase 2 is, and the county and the town will go into discussions. There are other concerns with the town getting involved, and the town does want to get involved. We do want to clean this site up. As I said, we've been working on this, looking at this. I go by it 10 times a week myself. It probably for a good 8 years. And we would like to see this property developed into something useful and clean. There is a question of whether or not there's civil liability. There may be civil liability by the town or the county for anybody going in there for any negligence, any damages done, not so much to the property, but to the environment, to two different places or two different entities. One is the governmental agencies. The EPA and the DEC could actually look at whoever is trying to develop the property or clean up the property, be it the town or a private individual, and find they're not doing it correctly or improperly, and levy fines or require certain actions or costs. That's number one. Number two, there's also the potential, and I'm underscoring potential, liability to individuals who may be affected by a cleanup. For example, if you go into a property and you dig up and open up a field where gases or liquids seep out and go into somebody else's property and cause either physical damage or property damage, you could be opening yourself up to liability. And it could be pretty great liability. Now, the good news in looking at the law on this is that there are tax credits for developers, private developers who go in and develop a property or clean up a property, and there are both, there's tax credits both federally and particularly through the state, through the what's called the Brownfield Cleanup Program, BCP, which was enacted back in 2015. The state has expended billions of dollars on this program, and it's something that a private developer would apply to the DEC for, and they would receive tax credits, not grants necessarily, but tax credits. So anyway, this is just the first and probably what will be a number of discussions or reports I will have. This is just to give you an idea of what can be done down the road. We are working actively on this as best we can. It's been frustrating at every turn. As I say, Matt Chatfield's been involved for at least 5 years. He can tell you. The current supervisor's been involved since he's been in office, and all the board members are pretty aware of this particular corner, which potentially can be a great commercial corner. And I think that's something that would benefit the town and both visually and economically. So, anybody have any questions on this?
Yeah, if we pay for the testing, we're not obligated in any way to do any type of cleanup.
No, I'm thinking that the county they've already they have indicated to me that they sort of expect us to pay for the phase two. But they're going to go out and shop around and get somebody to do it, at least to give us a price. So I don't know. We'll find something. If we don't like the price, we're going to find something.
Well, why can't we solicit? Because if we're obligated to pay for it, or they don't want to share in the cost, we're not obligated.
Yeah, no,
that's the wrong word.
That's what I said. The frustrating part about this is we're the ones that are most affected. We have the county is too, but we're more affected. We have our hands tied. They are the only ones by law that can go in and get this temporary incidence of ownership. And they call it just temporary ownership. They can go in and basically own the property long enough to get somebody to come in and assess the environment. And then we go from there.
And John and Charlie, it's interesting. You did a very nice job. I will say this, that you might remember that 15 months ago, in March of 2021, we had Logier Consultants who we've been working with, and they gave us a $12,000 estimate to go and do the boring holes and all the phase 2 testing. Had a workshop on it, and at that town board workshop 15 months ago, what manifested itself at that time was 2 hurdles. One, it's a privately owned property. How does the town board justify putting taxpayer money onto a private property? That's a problem. That's a hurdle. The second hurdle, though, is the one I cannot get my mind around if there's any major risk of this, and that is that if we quarterback that testing and it shows that there's $1 billion of cleanup, the town cannot be in the liability position to do that. And that was what happened 15 months ago. And so we went back to the drawing board to try to address those 2 things. Now the reality is this, and it's been, the town directly has nothing to do with this property. That's a fact. Chain of title and how it works, the county is the straw that stirs the drink. They do real estate tax foreclosures. That's how it works. They've actually foreclosed on it about 17 times, Charlie, not 3 times, and they do not own the property.
No.
Because what the county does,
they sell the tax liens.
and this is, they used to sell the tax liens, but until the people who bought the tax liens, they weren't going to buy them on this property anymore, because it got 7, 10, 15, 20 years delinquent. The county does this thing where at their tax foreclosure, if nobody buys it at the auction, then they look at the property and say, there might be some environmental issues here. We don't want it, and they give it back to the private owner. And this happens, and then we just keep going and keep going and keep going. There's no end in sight, right? That's why that property has sat there for 20 years. Now, I'm going to call it what it is. It's a quid pro quo. I love that term. Last couple of years it's gotten an ugly mark on it, but I still like the term. Is that great? Or is it?
No, this is it.
It is. Yes. So it really comes down to this. The county will play ball with us, with the town. If we agree in an MOU, a memorandum of understanding, or an IMA, an intermunicipal agreement with them, to bear the cost of this phase 2 testing, and in exchange, Charlie, they will execute all that court mumbo jumbo that you just said for the 20 days and get temporary control so we can go do the testing. Now, that brings us right back to full circle of 15 months ago. Does the town board, as we're working with the county on this, how do they feel about the town paying money for, well, Logier was gonna do it for 12 grand. The county has to do it with their content. They said this to us, it's not, they don't bid it out, they have a firm they do business with under contract, and their attorneys are looking to give the scope and whatever. We haven't heard that price tag.
No.
But we have a point of reference, because Logier Consultants was gonna do it for 12,000. So issue one, right back to 15 months ago, is how do we feel about the town paying for that? Now, the reality is this, we, in the last 15 months, have other funding options now. We have ARPA money that could be used for this, right? And the second thing, and this is the one that I still, and Charlie, this is where we need your assistance. And the county feels very strongly, 2 attorneys at that last meeting, right? They brought 2 of them, Charlie. That tells you how serious. They made it pretty clear that this process you just described totally keeps them out of the liability of any found problems.
Keeps them up.
Keeps them out. But they said, and I give them credit for this, one attorney to another, professional courtesy, Charlie, we're not making any statements that keeps the town out of liability. So that's where it's on us to do that research, precedence, all that, to see if we agree to do it, how do we feel about the chance that the town would be in a risk liability if there is a ton of remediation?
And that'll be something, obviously, I will advise the board on, probably, in a workshop or something if we were talking about, or, I mean, sorry, an executive session. But I think we have to look at each step. We have to see what the liability is of phase 2, and then beyond phase 2, if there's anything necessary. There may not be liability in phase 2, there may be in phase 3. And so it's really not, I've done a lot of research on it, it's not clear.
No, it's not. I mean, that's where...
And that's, the one thing that's good is I think the state, which of course has put an enormous amount of regulation here, did come up with this BCP program because I think they realized they wanted to encourage a cleanup of these, that having dirty property sitting around was doing nobody any good. They wanted people to get involved, and they realized they had too many penalties and not, well, I guess too much stick and not enough carrot. So,
yeah. And Matt, you're here, and not at the podium, but we're in the middle of we got a grant for looking at the whole neighborhood there, the West Webster hamlet, and the focal point, the nucleus of that hamlet is ridge and gravel. And ridge and gravel, everybody knows, is 600 ridge, the furniture strippers, and the old Jake Pads. Like I said before, the town has no direct tie to this stuff, legally and whatever. The town's problem is that that property sits in our town, and if something isn't done on it, then it just will continue the degradation of that whole neighborhood. So this grant that we got, and is it Nichols, who's the consulting firm that's... Ingalls. This is all for naught, if you ask me, if we don't in parallel get this thing taken care of. It's all for naught. So,
anyway, this is only part 1.
Yeah.
We'll go.
Yeah, because you're right. If they come back and say our contractor says it's $97,000 to do that testing, well, I didn't say at the time I'd advocate we pay 97 grand. I think 12,000 from Logier for the scope and all that. Okay, we can talk about that, right? So we'll see. You're right. We have to
One
see.
thing I will say I'm pleased about is that finally they have, as you commented from the last meeting, they had 2 attorneys and other personnel. They have finally taken an interest in this product, which is good. So hopefully we can work out a partnership of sorts.
Thanks. Any other comments, questions on that one? On our good friend 600 Ridge?
Yeah.